Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And we have a bench warrant arraignment in People v. Nicholas Hilliker, file 25-7076FH. Counsel, you want to state your appearances, please, beginning with the people?
Melissa Goodrich, Wayne County Prosecutor.
Good morning, Your Honor. Attorney Scott Grable, P53-310 on behalf of Mr. Hilliker. Thank you.
Good morning. And I'm told, Mr. Grable, that you'd like a breakout room to talk with Mr. Hilliker first?
I would, Your Honor, very briefly. And the court was kind enough, your staff, to call me. Obviously, this just came to my attention this morning, and I apologize. But if the court would indulge me, give me a few minutes. I don't think it should take very long. Thank you. If the court would.
No problem. No problem. Yeah, we have assigned counsel to cover arraignments, but whenever there's a retained appearance, we try to reach out to see, if you'd want to handle that.
No,
so let me create a breakout room for you to talk with your client.
Thank you, Judge.
We're back on the record, having given Mr. Hilliker a chance to speak with his attorney. And Mr. Hilliker, it is alleged that you are in contempt of court for violating a condition of your bond by failing to comply with the terms of that bond by not obtaining an alcohol tether. You have the right to have a hearing on that allegation where your contempt would need to be proven beyond a reasonable doubt. You have the right to the assistance of your lawyer at any such hearing to present evidence in your own defense and to cross-examine any of the evidence presented against you. If you are found to be in contempt of court, you could be jailed for up to 93 days or fined up to $7,500 or both. Also, if I believe that you are not complying with the terms of your bond, I can revoke that pretrial release or amend it. Mr. Grable, do you know how Mr. Hilliker wishes to proceed?
Yes, Judge. We're going to plead guilty to that charge, Your Honor.
Okay, Mr. Hilliker, you want to raise your right hand for me, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you can put your hand down. Mr. Hilliker, do you understand the rights that you have that I outlined for you?
Yes, Your Honor.
Do you understand the penalties that you could face for this bond issue?
Yes, I do, Your Honor.
All right, has anybody promised you anything in exchange for your plea of guilty to contempt?
No, Your Honor.
Has anybody threatened you to make you enter that plea?
No, Your Honor.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to being in contempt of court, guilty or not guilty?
I'm guilty.
And Mr. Hilliker, did this court amend your bond back on November 25th, requiring you to obtain an alcohol tether within 48 hours?
Yes, Your Honor.
And do you have an alcohol tether now, it being December 9th?
No, Your Honor.
All right, Mr. Grable, you satisfied with that factual basis?
I am, Your Honor. The court, in my opinion, has complied with the court rule.
Okay. Ms. Goodrich, you satisfied with the factual basis?
Yes.
All right, well, Mr. Hilliker, I find that your plea to contempt is knowingly, understandingly, and voluntarily made, and I do accept it and find you in contempt of court. So I suppose then I'd like to hear from counsel whether we ought to impose a contempt penalty at this time or whether we ought to revoke bond and address it at the next hearing. So I guess I'd like to hear from both sides. Mr. Grable, what's your input into what we ought to do going forward here?
Well, Your Honor, honestly, to be honest, the client was certainly forthright with me, Your Honor. Although it's not, I think it's important so the court has some nuance of it. Obviously, the reason that the tether wasn't hooked up, and I would rather just be candid with the court because Mr. Hilliker wanted me to do. He had a relapse and he consumed alcohol. I don't think the court is probably shocked by that epiphany, but I think it's important that it's nuanced. I just didn't want the court, and the court probably didn't surmise that the reason was he was thumbing his nose at the court. I know he made the appointment to hook it up. Obviously, he didn't follow through with it, Your Honor, and that is the reason why. That's not a justifiable excuse, obviously, Your Honor. But again, that would give rise to another violation. But I think it's important that the court knows that. I don't want to be flippant and just indicate, well, he didn't hook it up, he got busy or anything. I think that's disingenuous to Miss Goodrich. I think it's disingenuous to the court. Obviously, Mr. Hilliker has a serious drinking problem, Your Honor, but that's his problem. It's not your problem or mine. It's his responsibility as an adult to maintain his sobriety, not just for this case. That's certainly primary, but for his well-being. Obviously, the only thing I could tell the court is he did not compound it by drinking and driving. But again, he certainly compounded it by putting himself, his freedom in jeopardy at this particular point, and obviously jeopardized his case. Obviously, Your Honor, my concern at this particular point is he has to address this drinking problem. But again, he put himself in this position. He said to me, and when we had the breakout room, he goes, "This isn't the judge's fault. The judge has given me every opportunity, and I haven't done what I needed to do." So it's not that I want his bond revoked, Judge. It's just, obviously, if there was some modification, obviously, if he gets out, this can't continue. I mean, this is unacceptable. I appreciate the fact he was forthright with me and gave me permission to share this with the court. That's wonderful, but I would prefer not to be here. I think he's a good person, but I can't have him drink and violate the bond. I can't have him drink. And I mean, I'm glad this is not a drinking and driving scenario, but I can't have him do that either. We could be here on a fatality. I mean, the violation is serious enough. It's not just about hooking up the tether. It's about the consumption of alcohol. But I think it's important the court understands that. And I didn't want it to be the elephant in the room. I think the court has a right to know that. And I think Mr. Hilliker wanted me to share that with you. But he makes no excuses. He understands that's no excuse. Whether you call it a disease or not, it doesn't matter. The court made themselves clear. The tether, whether there's no excuse for not hooking up the tether, he should have availed himself to the court once he drank. And I'm not trying to allocate for the prosecutor, but he understands that and takes responsibility. And whatever the court deems appropriate, we're going to have to accept, to be frank.
All right, thank you, Mr. Grable. Ms. Goodrich, your position or input?
Your Honor, due to public safety, given the nature that this is a drunk driving charge and he has 3 prior ones, I would ask the court to revoke his bond. Given his honesty, if he is able to get inpatient treatment, I would be willing to sign a stipulation for that.
Okay, well, here's what I'm going to do then, Mr. Hilliker. I was concerned back on November 25th because we had you skipping the last blow of an evening, which caused me to think you were doing some maintenance drinking. And so I thought, well, we'll do the alcohol tether. This came to my attention today because we saw that even last night he skipped the last blow of last night. So I suspect that is in fact what's been going on. And he didn't get the tether. This is an OWI 3rd offense. Looks like it's a true 4th. He's got 3 prior convictions. That does raise concerns expressed by everybody here, and I think even by Mr. Hilliker, to his credit, through his counsel, that this is a problem he's having a hard time managing. So I think rather than me impose a contempt sentence, like if I were to say 93 days on a contempt judgment, we're kind of locked into that. I think what I would rather do instead, I know Mr. Hilliker was supposed to meet with our recovery court case manager today for a screening into recovery court, was unable to do that. She can maybe meet with him while he's in the jail. I'm going to set this for a contempt sentencing at your docket call, which is scheduled on January 6th at 1:40 p.m. But I am going to revoke your bond, Mr. Hilliker. So you're going to be held in the custody of the Sheboygan County Sheriff until further order of the court. And what that does is it keeps you there for now, and frankly through the holidays, which I think present an increased risk of relapse for people who aren't managing a substance abuse problem very well. But it doesn't lock us into you being there for 3 months or more. We can, on January, talk about what the plan is moving forward. We can have you assessed for recovery court. We can see if there's any inpatient that's appropriate. We can kind of take a survey of the landscape at that point. So that's what I'll do. I'll revoke his bond. I'm not going to impose a definite sentence right now. We'll set it for the existing docket call at January 6th at 1:40, add a contempt sentencing for the same date and time. And Mr. Grable, you may appear by video for those hearings if you wish, and we can put Mr. Hilliker in a Zoom room like we have today.
I appreciate that, Judge. And may I ask, or ask Ms. Goodrich, we appreciate the court as well as Ms. Goodrich's input as well. Does the jail, I assume I'm going to recommend he avails himself. I'm not sure, does the jail have any type of AA or anything? Because he certainly should avail himself while he's in jail. And that's a given, of course. I just, if that has it, he should do it to get something started to help himself because he's got a problem.
They do have, there's programs that earn credit off a sentence that he can't do on pretrial detention. But my understanding is there's other programmings that don't necessarily have credit with them, but they're available to anybody in the jail, sentenced or pretrial detainees. They have AA that goes in there. They have Celebrate Recovery that goes in there. So if he wishes to participate voluntarily in those programs, that they do come in on a weekly basis.
Thank you for that guidance, Judge, because he should take advantage of that, obviously. Whether it results in credit or not doesn't matter.
Okay.
Thank you,
All right.
Judge.
Well, thank you all very much.
Thank you.
Thank you for accommodating me. Thank you, Ms. Goodrich. Appreciate it.
All right.